I have to hit OK. Hold on. Welcome, everyone. Oh my God, now our phone's ringing. To our mid-year labor law workshop. I'm Nancy Hoffman-Baniak, and I'm CEO of the Greater San Fernando Valley Chamber of Commerce. And it's my pleasure to introduce you to our speaker for today's mid-year labor law workshop. This is Giuliana Gabriel, JD. Giuliana is the HR Compliance Director at the California Employers Association, CEA, where she assists a multitude of employers with HR compliance and training. Giuliana is a whiz when it comes to drafting policies and procedures, creating employee handbooks, and providing day-to-day HR guidance. Her impressive work includes conducting numerous workplace investigations for employers of all sizes across a diverse range of industries. Giuliana's background in employment litigation before both state and federal courts, as well as administrative agencies, makes her exceptionally well equipped to guide businesses through the complexities of California's HR compliance. Her practice included defending employers in discrimination, harassment, wage and hour class action lawsuits, and provided her with real-world insights that are invaluable to California employers today. Before joining CEA, Giuliana was an associate attorney at Downey, Brand and Gibson, Dunn and Crutcher. She's a graduate of California Polytechnic State University, San Luis Obispo, and Pepperdine Caruso School of Law. So please join me in giving a warm welcome this Friday to Giuliana. She presents our update. And if you have people in the background, please put it on mute so that way you can hear the workshop.
Thank you so much, Nancy, for that wonderful introduction. We really appreciate the Greater San Fernando Valley Chamber for sponsoring this event today, and we do have a lot of information to cover for you. So I am going to go through this. It's going to be about an hour, and if you do have questions about the content, you can put those in the chat box. I'll try to monitor that as we're going through and kind of answer some questions as we go along. So I do encourage you to do that. I want to make the most of this for you. All right, so let's jump right in and get started. So again, thank you for sponsoring today. And who is California Employers Association, or CEA? We are an HR consulting company. We have members located throughout the state of California and beyond. And our focus is on providing employers peace of mind with exceptional HR compliance solutions. So we want you to be able to focus on your business while we help you with the HR side. So if you join us as a CEA member, you do get unlimited phone support with us. So all of our members can call in Monday through Friday, 8 to 5. You'll get a live HR advisor on the phone, such as myself or one of my colleagues, to help you out with any sort of question. So it might be an employee relations issue, wage and hour. Maybe you have a question about administering a leave of absence or a reasonable accommodation, and we can help you out with that. Our members also get access to our extensive library of sample forms, policies, and fact sheets. So something that we're really excited about is we have a workplace violence prevention toolkit to help you put that together by the July 1 deadline. So all of our CEA members have access to that. And we can help you out with training. So trainings for your supervisors, managers, HR audits, customized employee handbooks, you name it. So please reach out to us. We have our contact information there if you're interested in learning more about our services. All right, and I do want to note today that this presentation is for educational purposes only. It should not be relied upon as legal advice. So if we're going through the training and an issue of legal significance comes up for you, maybe you're concerned you haven't paid somebody properly, it's really important that you get legal advice specific to you and your situation from your own attorney. But we can answer questions about the content. So as I mentioned, you can put those in the chat box. All right, so what is on our agenda today? We are going to start with our wage and hour updates. It's always important that we are paying people properly, and in California, it can get a little bit complex. We have multiple different minimum wage requirements, so we're going to talk about that and what's new. We're going to dive into the workplace violence prevention plan requirements that are due by July 1. So this is a big one that we all want to pay attention to, and probably the highest priority item that we will be discussing today. We're also going to go over some new rights for pregnant workers. So this mid-year season's a little bit interesting because we've actually had a number of federal updates. So typically we have so much to talk about with California, and their rules are typically more stringent, but we actually have some important federal rule changes that we're going to discuss that will impact all employers. All right, so let's jump into our wage and hour updates, starting with our state minimum wage and exempt salary minimums. So as of January 1, 2024, the minimum wage increased again. So for your non-exempt employees, we are looking now at $16 an hour at the state level. And it used to be that there would be a difference in minimum wage depending on the employer's headcount, if you had 25 or fewer or more than 25. So luckily, they have simplified that area where everybody is now on the same page at that $16 an hour. And we've continued to see these increases based on inflation. So there's automatic bumps anytime the CPI's inflation goes above 7%. So that's why we bumped up from the 1550 to 16.
Giuliana, I just want to chime in here that because most of us are in LA. So our
We're
minimum
going to
wage
talk
was
about
okay.
local very
Okay, good.
soon.
Thank you.
Yes, yes. California makes it fun. We have a lot to talk about. So for the exempt employee salary, that is always 2 times the state's minimum wage times 2080 hours a year is how you get to that figure. So for 2024, the exempt salary minimum is 66,560. And that is something that you're not able to prorate based on hours worked. So you say, well, we have a salaried person, but they're only working 30 hours a week. Can we prorate it that amount? And the answer is no, that is the absolute minimum. And there's also duties tests that someone has to meet to be exempt. So if you're not able to sustain that in your budget, it's really important to reclassify that person as a non-exempt hourly employee. So in California, anybody can be non-exempt, whether you're an entry-level worker or even a CEO. It's always okay to be non-exempt, but not everyone can be exempt. And we have a great fact sheet if you do need to make that transition for someone, especially if they've never been used to tracking their time and taking their meal and rest breaks. And everybody has access to this fact sheet. So we included the bit.ly link there, and you can put that in your browser. And now, as Nancy mentioned, we also have to make sure that we are complying with local minimum wage requirements. So in California, there's now over 40 different local ordinances that may apply, which means there's certain localities that we have to pay more than what the state requires based on those ordinances. Some localities also have their own special paid sick leave rules and predictive scheduling rules. So it's always important that you're checking out that website where you have your employees located. Now, the local minimum wage is based on where the employee is physically working. So a lot of employers missed this during COVID. They sent people to go work from home and maybe another city or another locality, and they didn't check, well, is there a local minimum wage requirement there? Because it's not based on where your office or headquarters is located. Same thing if you're sending workers to different client sites. And they're traveling to different areas to do their work, you always want to check those local minimum wage requirements. They typically go up and increase a batch of them on January 1, and then the majority of the rest of them on July 1. And so we do have some July 1 increases that are going to be very relevant to the San Fernando Valley. So I'm going to cover what those increases, what cities are increasing. So for Northern California, as of July 1, minimum wages will go up in Alameda, Berkeley, Emeryville, Fremont, Milpitas, and the city of San Francisco. And then in Southern California, we have Los Angeles City going up, Los Angeles County, the unincorporated areas. So I imagine this is relevant to many of you. As of July 1, that is going to be $17.27 an hour will be the minimum wage in the unincorporated areas
So
of LA County.
just so you know, we're incorporated. The San Fernando Valley is majority the city of Los Angeles.
Okay.
And
And
then
that one is 1728
correct.
as of July 1.
I put the link in the chat. If you are in Stevenson Ranch or some of the little outlying areas, then I'm going to put in the county, which is for the unincorporated, because otherwise the other cities that are in the San Fernando Valley fall under the state minimum wage.
That's really helpful. So you have a mix of all
We
three.
have 5 cities in the San Fernando Valley.
Okay.
The majority, 2 million people, is the city of LA.
Got it. Okay. So LA 1728 as of July 1, LA City, unincorporated 1727. And if you don't fall into one of those, you're just deferring to the states of $16 an hour. Thank you, Nancy. It's super helpful. Malibu, Pasadena, Santa Monica, and West Hollywood hotels. So again, we have a bit.ly link here. You can put it into your browser and it will bring up a free fact sheet of all of the local minimum wage requirements, not just these, but everywhere as of July 1, 2024. You'll have all of those on that fact sheet, so you can go ahead and access that if you do send workers to different areas throughout California. You can check it and make sure that you are staying in compliance with those. All right, so I want to jump now into a Q&A, wage and hour Q&A. So before our employees start their day, we have a security screen process. Employees must scan their badges and go through a bag check and metal detector. The process is about 5 to 10 minutes each day as a line often forms. Employees then clock in to start. Is this okay? I think I already heard someone say no. Any other guesses in the chat? What do we think here? Yep, so someone already answered this for us. The answer is no, and it looks like many of you are saying that in the chat. So this is already kind of on your radar, and I'm glad to hear that. That is probably not okay under almost all circumstances. And there's now this 2024 case. It's Huerta versus CSI Electrical Contractors. And it's really just another reminder that employees should not be engaging in any pre- and post-shift work that is off the clock. So it seems like the California Supreme Court keeps giving us these reminders with these pre- and post-shift work cases that we want to make sure we are tracking that time. So I want to jump into the specifics in this new 2024 case in Huerta. So in this case, the employer had a security checkpoint to enter and exit the work site. And it was this nature preserve that these contractors were working at and located in Monterey and San Luis Obispo. And how they would access this work site is through kind of this guard shack where they would drive in. And as they were driving in, the guards would scan their employee badge and then sometimes peer into vehicles or peer into the truck beds. Reason being is they wanted to make sure they weren't taking anything that they weren't supposed to into this nature preserve. And what was alleged is that a line would often form, taking anywhere up to 10 to 30 minutes to get through this security checkpoint. And as you may have guessed, this time was not tracked. It was off the clock. So the question was, is that employer on the hook for those unpaid hours? Is it compensable as hours worked? And the California Supreme Court, I think to no surprise, said yes, because the employer was requiring specific and supervised tasks during that checkpoint process, it is compensable time. And remember, if we mess something like this up, it can have a lot of implications. So there's that unpaid time. It might have actually pushed them into overtime, and we have daily overtime in California for people working more than 8 hours. So they may have had an 8-hour day and now there's this overtime that's being incurred, and the wage statements were probably also inaccurate. So a lot of penalties can follow when we mess up our wage and hour processes. So it's really important to get this in check. So just some general reminders. We do not want to permit pre and post shift work that is off the clock. And so some other examples, just beyond Huerta, beyond these security screens, gearing up machines or logging into computers. This is one that a lot of employers miss and you want to be careful about, because that could take a few minutes of time each day. And that's time that the employee's losing out and they're not getting paid for that. And some people, they say, well, we enter in our time in our computer. So what do we do about this? Well, can you have an exempt person get the computers geared up for the morning? Can you leave them on so that it only takes a few seconds to go log in? Because if it's a few minutes, you're probably in that dangerous range where now someone might bring a claim. We want to think back to that case a few years ago, the Troaster versus Starbucks case, where basically the court said, we're not going to follow the federal rules, their de minimis rules, where they might overlook a few minutes of time. Here in California, we want to make sure you're tracking as much time as possible. And so even if it's a few minutes, we want to count that. That should be accounted for. And so they didn't give us a bright line rule on exactly how many minutes before it becomes an issue, but they said even just a few minutes, we need to be tracking it. And there's technology now out there to be able to do that. Donning and doffing of protective gear, that can take time to put on safety goggles, gloves, and gear up. Answering emails or discussing work tasks for the day. This is an easy one to miss. Let's say someone's walking into the building and their supervisor catches them. Hey, I want to talk to you. This is what I want you to do today. And they're not clocked in. That's a potential issue. That's minutes of time where it's work-related conversation. Locking up and setting the alarm or cleaning up at the end of the day, which were facts in that Starbucks case. So we want to make sure that this time is accounted for. So we would recommend number one is have a policy alerting employees that if they are working outside of their shift times, that they need to get supervisor approval or authorization to do that. And then train your supervisors that if they see this pre or post shift work happening, that they follow up with that person and have them correct their time card. Even if it was unauthorized, we always have to pay employees for that, but we could also discipline employees for engaging in that unauthorized work. But have your supervisors on it, that they are trained to make sure that that employee follows up and corrects their time card. All right, there were a few other issues in the Huerta case that were addressed. So another one was drive time. So after that security checkpoint, then employees had to drive another 15 minutes before they reached their employee parking lot. And during that time, they were required to comply with some basic rules such as speed limit, not being under the influence of drugs and alcohol. And interestingly here, the court found that this drive time was not compensable. So they said this is basically part of their normal commute. And even though they had some limited rules that were placed on them, this would turn every time that an employee comes to the work site as compensable time if we can't have just some basic rules when they're driving up to our parking lot or they're entering our building and they're going up the elevator, and that takes a little bit of time. So luckily the court didn't take it that far. So they said just because somebody's on your site, they have to comply with some basic rules, doesn't mean that it's automatically compensable time. So that's some good news for California employers, is they did kind of draw a line in the sand there. The other issue that they addressed were these on-duty meal breaks. So there was this agreement between the employer and the union under the CBA. The employees had to remain on the premises for meal periods because they were out there on this nature preserve, but they were not paid for that time. And the court found, regardless of your agreement, even if the union agreed to it, on-duty meal breaks always have to be compensated. So they said you can't waive that law in a CBA. We always have to pay for those on-duty meal periods. So I want to go over some reminders when it comes to the meal breaks that are good reminders for everyone. Number one is on-duty meal periods are actually rarely permitted to begin with. So it's very specific when we're allowed to do this. It's only when the nature of the work prevents an employee from taking a meal break. And the employer and the employee must voluntarily agree to it. So it's the employee's choice whether they're going to do it. And some cases where the court has found that the nature of the work truly prevented it was a single security guard at a remote location, an employee in a single small coffee kiosk. So it's been pretty limited where they've kind of blessed that. And they typically say that added cost or inconvenience of having to have someone relieve the person for the meal break is not enough to say that the nature of the work would prevent a meal break. So they're already rarely permitted to begin with. So what we would suggest for most employers is that you're scheduling those meal breaks and you're allowing employees to leave the premises. That's required for both meal and rest breaks. And then anytime a meal or rest break is insufficient and it's at all attributable to the employer, whether the supervisor said, hey, can you just take care of this, one more task, or interrupted them with a question, or they had too much work to get through that they had to do it, or they might, face disciplinary action. Any of those cases, we would say then we recommend that you pay that premium pay. So that's required anytime it's the fault of the employer. And that is 1 hour of pay for all meal break violations in a workday and 1 hour for all rest break violations in a workday. And it's an hour's worth of pay at the regular rate of pay. It also needs to be reflected on the wage statement. So anytime somebody's paid that penalty, we should see it reflected on the wage statement as well. And remember, that's in addition to any time they work during the meal break. So let's say they work through their meal break and that was 30 minutes, that's on the clock time, plus they get that hour as penalty pay. So we want to make sure we have that shored up because this is an easy area to run into some compliance issues. All right, so now we're going to shift gears a little bit and we're going to talk about some very important updates when it comes to health and safety and what we want to be prepared for by July 1. So last year, there was a bill called SB 553 that passed, and it created this new requirement to establish, implement, and maintain a written workplace violence prevention plan by July 1, 2024. So this is actually the first general industry workplace violence prevention requirement in the nation. So California is the first to do this, where similar to your injury and illness prevention plan, you need to have a plan that's focused on mitigating workplace violence hazards. We've actually had healthcare employers have had a requirement like this for a number of years, and Cal OSHA was contemplating putting together a regulation for general industry, but the legislature stepped in here and said, we're going to require this now. We're going to pass it in legislation. And Cal OSHA has until December 31, 2026 to come out with their own regulation. So we might see some changes or some more clarification when that happens, but it is fully enforceable as of July 1. And it applies to virtually every public and private California employer with very limited exceptions. So most of us are going to want to make sure that we have this in place, and we're going to unpack some of the requirements here for you. It does include some unique employee engagement requirements where we actually have to solicit the feedback of our employees in developing and maintaining our plan. So we're going to want to get that on our calendar and make sure that that's one of the first things we do is reach out to our employees and give them an opportunity to participate. There's also annual training requirements of our employees. So we're going to have to get used to this, similar to harassment prevention that's every 2 years. We're going to have to get used to this workplace violence training that's going to be every year. And that's something, again, that you're going to want to have done and completed initially by that July 1 deadline. So let's talk about, well, what are the exceptions to this? Who is exempt? So there is an exemption for teleworking employees. So those who are completely remote and they're working at a location of their choosing that's not under the control of their employer. But this likely wouldn't apply if they're hybrid or they even occasionally come into the office for meetings or visit client sites. Then they likely wouldn't fall under that very narrow exemption. So for an employer to be completely exempt, that would mean every single employee would have to be 100% remote, which is just probably not really the case for most employers. Then we have this, what I'm going to call small employer exception. So places with fewer than 10 employees at any given time, and it cannot be accessible to the public, and they would still have to have an injury and illness prevention plan. So let's say you're a small coffee shop, you have 5 employees, you serve customers, you're open to the public, so you would still have to have a plan. Healthcare facilities, as we talked about, they're already covered under their own standard, and then certain prisons and law enforcement agencies. And that's it. Everybody else has to have this plan by July 1. So what are some examples of workplace violence? This is defined really, really broadly. So it can be a physical attack with or without a weapon. So that can be things that we think of like, slapping or punching, but also lesser things like hair pulling, scratching, spitting on someone, a threat of physical force or use of a weapon, sexual assault or unwanted verbal or physical sexual conduct. So now when we receive sexual harassment complaints, you might not think that a verbal derogatory comment would be workplace violence, but it actually would fall under the definition. And then animal attacks. So it doesn't even have to be from a person. And why this is relevant is for every incident of violence that happens in the workplace, we're going to have to record this on a violent incident log. So that is a new record keeping requirement. So it's important to understand just how broad this is. It could also apply in a situation where somebody made a joke. So they might say, oh gosh, I could just kill her. And if it was taken seriously, that could constitute workplace violence, even if they weren't being intentional with it. So it's just anytime it results in psychological trauma, stress, or injury, but injury is not required. So you can see the definition is very, very broad, and our plan needs to be aimed at addressing all of these different forms of violence. And that can come from a stranger, can come from coming to commit a crime, could be a customer, a patient, another employee, or even when domestic violence spills into the workplace. If someone threatens their partner while they're at work, that would now be workplace violence because it's happened in a place of employment.
Juliana,
All right.
question in the chat. When we say
Okay.
not accessible to the public, does that include a small residential facility, visitors and vendors coming off it? What's your thoughts?
Yeah, unfortunately, they haven't defined that term. So it's not defined in the statute, and Cal OSHA has yet to define it. They do have some FAQs that they released in March, and they didn't define that, which we were hoping that they were going to. So we would say err on the side of caution. So even if it's not that you serve customers, but you do have vendors or visitors, I would probably say yes. I would lean that way because it's better to be safe than sorry when it comes to this, because there are penalties that Cal OSHA could assess. So hopefully they'll give us some additional guidance on that.
And then is there, 'cause some things are just being sent to me. Is there like, if you have less than 5 employees, do you still have to comply?
If you have less than 5 employees and you're open to the public, which we talked about is not really defined, then yes, you would. So that is a big misconception that very small employers don't have to have one, but you do. And then it looks like someone said if we have an office with no public access, such as a bookkeeping company or IT with 10 or fewer employees, you'd probably be fine, would be my guess. And it's at any given time. So even if you say, well, normally on site, we only have a few people, but we might have a meeting and we have up to 12, then you would want to have a plan. But if it's at any given time, fewer than 10, then you would be exempt if you're not open to the public. So great questions. We're hoping that they'll clarify more of this once they come out with their regulation or additional FAQs. But for now, we're saying it's probably better to have a plan in place. All right, and we also have we've been receiving some questions about the training requirements. So does it need to be a certain duration like harassment prevention? Are we required to cover specific topics? So the answer to that is there's actually no specific duration requirement like we have with harassment prevention. We would probably recommend that you set aside about an hour at least of time to be able to meet all of the requirements, but it has not been defined yet. Now, here's the key that I want to really drive home is that the trainer must be knowledgeable in the employer's specific plan, and the training needs to be interactive. So this is not one of those situations where we could just pull an online on-demand course off of the internet on workplace violence and play that and be done. You could do that to supplement your training, but you won't be fully compliant. So the trainer really should be someone in your workplace, one of your plan administrators that's responsible for the plan. Or if you hired, let's say, a safety consultant, they've reviewed your plan, they're familiar with your specific procedures, then they could train on it. But that's a little bit different than what we've been used to. The training needs to cover specific definitions that are in the labor code. So that's labor code section 6401.9. That's where SB 553 was codified. That's where you can find the definitions. And then it also has to have topics customized to the business, as I was mentioning. So how do employees at your workplace request a copy of the plan? How do they participate? Where do they report concerns? So is it to their supervisor? Is it to your HR person? Do you have a safety manager? How do they seek assistance? And what are strategies to avoid harm? Hazards specific to their job. So again, if you're public or customer facing, you may have different hazards than a small corporate office that's not. Corrective measures implemented by the employer. So you might say, we've installed these surveillance cameras, we have a badge-in system, this is our code word if there's somebody dangerous in our building and we all need to get out, or this is our PA announcement. Those are things you can cover in the training along with your evacuation routes. And then information on that violent incident log, just basically what is it and how can employees request a copy of the records that they are entitled to. That is one of the records they are entitled to. That violent incident log would remove all identifying information. So similar to our Cal OSHA 300 reporting forms, it would have just basic information about the incident, and then you'd want to have your confidential report that has all of the names and everybody that was involved. All right, so at a high level, what do we need to focus on by July 1? So number one is creating your written plan. Cal OSHA has a template for this. It's a Word document. It's about 18 pages long, so set aside a few hours to take a first crack at it. And they have everywhere in red where the employer should fill in information specific to their business. So that template will take you through all of the requirements. We're going to want to solicit employee feedback, and if you have a union feedback in that plan. So they get to give feedback in things like how do we mitigate hazards, how should we report, and even what should that employee training look like. So this is why I said that's a priority item that you would want to start as soon as you can. And that can be something as simple as sending out an email and saying, hey, we would like your feedback. Please respond to us on these specific topics. You could hold meetings where you take notes on what's the employee feedback, send out a survey via SurveyMonkey if you can do that. So there's really no one size fits all, but I would put that as a number one to do. And then after you've completed the plan, then you can conduct that annual training. And that, again, it's every year, but initially this year by that July 1 deadline. There's also a requirement to schedule periodic inspections and hazard corrections if you find a hazard, and safety meetings, and including one initial hazard inspection when you're putting the plan together by July 1. Anytime there's a workplace violence incident alleged, we're going to want to investigate that now, and we have certain record-keeping requirements like that violent incident log. So CEA does have a do-it-yourself package available, and we're holding a webinar on June 20th. It's a 90-minute comprehensive webinar on WVPP, and if you're not a member, that would be a way to get access to our toolkit that helps kind of ease a lot of these burdens and put the plan together. So we have employee survey questions, for example, a hazard inspection form, investigation template. So a lot of the forms that you might need that Cal OSHA hasn't provided, they provided just that initial template, as I mentioned. So we do have that option if you want to register. It looks like there's a couple questions. I'm going to just check out here. So the template is on Cal OSHA's website. I don't have that link at the moment, but I'm sure we can get that for you. And it is free and accessible to everyone. All right, and looks like that covers everything. All right, and the last thing in the health and safety realm that I want to talk about is this new heat illness standard and plan that may be coming. So we have a lot of plans. We have our injury and illness prevention plan, our workplace violence prevention plan, and COVID prevention plan, and now we're also adding heat illness. We already have one for outdoor places. Now indoor places of employment may need to consider an indoor heat illness. So on March 21st of this year, Cal OSHA voted to adopt this indoor heat illness standard that would apply to most indoor work areas when temperatures reach or exceed 82 degrees. So that may be places like manufacturing facilities, restaurants, warehouses. Most corporate offices, that wouldn't be a problem because they have AC, right? At the last minute, the California Department of Finance withdrew their required approval. So the standard is now actually on hold. So Cal OSHA is set to vote again June 20th. And let's say they do, vote to approve it again, which I think they're likely to do. It may take effect as early as this July 2024. So if you're in one of those environments, then you're going to want to prepare to probably put together that plan once it's formally approved. And then remember, for outdoor places of employment, we've already been required to maintain a written heat illness prevention plan, which includes access to shade, cool water, cool down breaks. And if you are a CEA member, you can refer to our heat illness prevention toolkit that will walk you through putting that plan together. So we already have one in outdoor. Now we may also have one coming for indoor places very soon. And thank you. It looks like Fuyumi put the link to our event on June 20th on our workplace violence do-it-yourself package. So you can access that there, as well as it looks like the link to the model plan was put in the chat box from Cal OSHA. So thank you all for helping me with that. All right, so now we are going to shift gears here and talk about some new employee rights and protections. And as I mentioned, we have some for pregnant workers. We're also going to be talking about harassment and some AI developments. All right, so there was this new federal law, the Pregnant Workers Fairness Act, or PWFA, that passed last year in June 2023. But there is an EEOC, Equal Employment Opportunity Commission regulation, that's the enforcement agency, that is going to become effective in just a few days on June 18th. And that really further clarifies the PWFA and what's required of employers. So that's why we want to pay attention to this. Now, this federal law is modeled after the Federal Americans with Disabilities Act and applies to employers with 15 or more employees. And so you may be wondering, well, why do we need the PWFA if we have the ADA that protects people with disabilities? And this law is actually more expansive than the ADA. So it requires accommodations for limitations, not just disabilities, but lesser issues, limitations related to pregnancy, childbirth, or related medical conditions. So for example, if somebody's experiencing occasional morning sickness, they need to take some time off, or migraines, or they need to attend those prenatal appointments. They might not be considered disabled by their pregnancy, but they have these things that they need to attend to that we would need to accommodate. This law also goes beyond just strictly pregnancy. So there may be accommodation requirements or protections related to reproductive choices, contraceptive use, infertility issues, menstruation, miscarriages, stillbirth, all of those things would be wrapped up to the PWFA protections. So now you might be wondering, well, don't we already have most of these protections in California? And that is correct. So I'm going to review because there's a few things that go beyond what California requires that we're going to want to pay attention to. But I first want to review, what's the status in California already when it comes to pregnancy? So California law already requires employers with just 5 or more employees to first reasonably accommodate employees that are disabled or affected by pregnancy. So that's very similar to the limitation language. We already have this requirement. So if that's certified by their healthcare provider that they need a reasonable accommodation, maybe they can't lift for a period of time, or they need to sit down more, or they can't be around a certain toxic substance, right? Then we would accommodate them for that. We also need to provide potentially up to 4 months of pregnancy disability leave, which is 17.3 weeks, as certified by the healthcare provider. So it doesn't mean that someone automatically is entitled to up to 4 months in California, but it could be up to 4 months if that's what their healthcare provider says they need. And a lot of the times how this usually plays out is you might have someone that, let's say they have, very intense morning sickness in the beginning, they might need some time off, and then they might be fine for a period of time. And then as they get closer to the due date, maybe they deal with an issue and need some more time off. So it can be used intermittently like that. It doesn't have to be all at once. And remember, in California, employees are eligible from day one. So there's no length of service requirement or hours requirement. As long as their healthcare provider certifies that they need a pregnancy accommodation, then they are able to take that leave time. They also have the right to reinstatement after returning from that leave, meaning we have to hold their job for them. And if they had healthcare benefits with us, we have to continue those healthcare benefits during that pregnancy disability leave. And of course, in California, we are not allowed to harass, discriminate, or retaliate against any pregnant employee. So as we can see, our protections are already very extensive when it comes to this area. So you may be wondering, well, does this PWFA, this new federal law, even impact us then as California employers? And the answer is actually yes. So there's some instances where this regulation is even more protective. And so we want to pay attention if you're an employer with 15 or more employees. If you're a smaller employer than that, the PWFA won't apply to you, so you don't have to really worry about it. So the biggest change, I think, is that there's this new requirement to temporarily suspend essential job functions. So how it's worked prior to this under the ADA and California's version, the FEHA, we only have to provide accommodations for someone who's qualified, which means they can perform the essential functions of the position. And if they're not able to do that, typically we would offer a leave of absence. Now there's situations where even if they can't perform those core functions, we may have to keep them on the job. And we'll talk about in a minute what an example of that might look like. The EEOC also says we have to provide certain what they call predictable assessments. They say there should be little to no interactive process. Basically, if a pregnant employee asks for one of these things, we should be providing this. And so I would almost call these like automatic accommodations. So they say carrying water, additional or longer breaks for eating or going to the restroom, sitting when standing is required, and standing when sitting is required of the job. So I think for the most part, employers are probably already doing this, intuitively. They're wanting to do the right thing here. So I don't think this is going to come up as an issue very often. But the EEOC really didn't place any parameters. So if you think someone's maybe abusing this, you say, well, they're going to the restroom every 10 minutes. Is there anything I can do about that? The EEOC doesn't really answer that question for us. So that's kind of still an open gray area as to, well, where do we draw the line on some of these things? And then we cannot request medical certification in certain instances. That's already the case in California a lot of the time. So such as with these predictable assessments or for lactation accommodations, if somebody needs to pump at work, we shouldn't be asking for a separate medical certification for that after they have already certified that they are pregnant. All right, so our employee Erica is pregnant. She presented a doctor's note certifying that she can no longer lift for the remainder of her pregnancy. And let's say Laura's job is taking boxes from the warehouse and loading them onto delivery trucks. Let's say that's pretty much her core functions. And so lifting is an essential function of her job. How do we respond in this situation? So according to the EEOC, if a pregnant employee is temporarily unable to perform one or even more essential job functions, you may need to offer light duty. You may need to change those work assignments. So maybe you transfer her to working in the office, help her, maybe help with some filing, whatever it is, for potentially up to 40 weeks, which is the typical duration of a pregnancy, unless the employer can demonstrate it would cause an undue hardship to do so. And undue hardship is a very difficult standard to meet. It's a legal standard. So this really kind of changes things, because instead of just offering a leave of absence as we normally would have in this situation, we have to maybe have to find ways to keep Erica on the job. And the EOC is not really clear. Well, does that mean we could cut her hours if we don't have enough work really available? They don't really provide parameters on this. So again, another gray area. I think this is going to be the biggest change and where we're going to see the most questions about, well, what do we do in these situations? And it might be, if it does come across as a situation for you, a good time to consult legal counsel with some of those ambiguities. One other area that I want to talk about is lactation accommodation. So California already has extensive protections regarding lactation accommodations and the right to pump at work. So CA members may refer to our sample lactation accommodation notice and request forms. So for example, they get to use paid rest break time to pump, and if they need more time beyond that, then unpaid break time to do that as needed. And we have to provide them a private location, shielded from view. It needs to have an outlet, it needs to be sanitary, and they need to have a sink nearby and a fridge nearby to store the milk or something similar to do that. So we already have a number of requirements. The federal law has kind of caught up to us with the Pump Act in 2022. So not a lot new there that we need to worry about, but I do want to call attention to this EEOC regulation that says a lactation accommodation can also include permitting the employee to nurse the child during work hours where the child is in close proximity to the employee. And the examples the EEOC provides is like a remote worker or somebody that takes a quick break to go visit a nearby daycare facility. So have that on your radar. Again, probably not going to come up that often, but have it on your radar because that goes beyond what California has required so far. All right, and I want to give a refresher on paid sick leave, and this should say SB 616, that was the bill. But on January 1, 2024, the annual amount of paid sick leave, our mandatory paid sick leave in California, was increased from the 3 days or 24 hours that we've been used to 5 days or 40 hours a year. So we want to make sure that we have upped those caps, those usage caps and accrual caps in our system. But for the most part, everything else has remained the same. So it's really just the amount of paid sick leave that we're wanting to pay attention to. So you can still use a front load approach where that's, for example, you grant it all on the same day every year. Let's say it's January 1st, you front load it, and then those 5 days, and then they can use it or lose it, and it refreshes that bank of 5 days on January 1st the following year. Or some employers use anniversary dates. That's fine. Or you can use the accrual method. And the default is still the same. The accrual rate has not changed. It's still that the employee would earn 1 hour of paid sick leave for every 30 hours that they work for you, if you use the accrual method where they earn it over time and it rolls over to the following year. But if you do use the accrual method, the cap on sick leaves increased. So it's no longer 48 hours or 6 days, it's now 80 hours or 10 days. So it's important that you've updated those amounts in your policies and then also in your payroll system, and that your wage statement accurately reflects the amount of paid sick leave available for use. So an easy way to do it, if you're able, is to say, let's say accrued paid sick leave accrued paid sick leave 80 hours, available sick leave for use 40 hours. If you limit someone to 40 hours a year that they can't use that entire 80-hour bank, you can make it really clear by just designating those two items. But it's the amount of paid sick leave that they have available to use that has to be on that wage statement. So some pro tips here. Double check that your wage statements are accurate, or it can be in another writing that's furnished at the time of payday. And then train managers on those extensive sick leave protections. So remember, we do not want to discipline employees or count it against their attendance when they're using their mandatory sick leave time, or we risk a potential retaliation claim. And I can't tell you how many times that gets overlooked, especially if someone has a lot of different varying attendance issues and some are protected and some are not. We want to make sure we have really good documentation on what the issue was every time, so we can determine if they're violating our attendance policies and we're not counting those protected absences. And then for PTO policies, if you combine sick and vacation into one policy, remember you have to satisfy both the paid sick leave requirements and vacation requirements. So for this reason, we tend to not recommend PTO policies because employees get basically the benefits of both, and it kind of complicates things administratively. So remember, once you combine it, it all has to be paid out at the end of employment. And also when they're using it for a sick leave purpose, it's very, very protected. And so you might have a lot of PTO and they use a lot of it for sick leave. And so just be careful with that. If you're a CA member, you can reach out to us. We can help you with putting that policy together, making sure it's compliant, or helping you out with your entire employee handbook. All right, another thing that I want to call attention to is this new EEOC harassment guidance. So the EEOC has been very, very busy this past year. So after nearly 25 years, in April 2024, the EEOC updated its harassment guidance with 77 different examples on what harassment could look like. And this is not basic stuff. It is, I think, very next level. Some of the terms are pretty nuanced. You may have not come across them before. So I would recommend for HR professionals and managers that you take a look at that document and some of the different examples of what might come up. And again, remember, this is on a federal level. So this is not just California. It's kind of, in a lot of ways, I think, catching up to what California has already required. But just some key highlights here. Harassment can include intrusive questions about sexual orientation, gender identity, gender transition, or intimate body parts. So again, if that's unwelcome and somebody doesn't want to talk about it and someone's peppering them with questions, that can be a form of harassment. Harassment of LGBTQ plus workers can include denial of access to bathrooms consistent with gender identity, as well as intentional and repeated misgendering. Someone's intentionally using different pronouns than what somebody has asked for, that can be a form of harassment. So now that's federally what they are saying. Sexual harassment can be based on pregnancy, childbirth, and related medical conditions. So that tracks that PWFA law that we just talked about. That makes sense. And then harassment can occur in remote work environments, which I'm sure all of us know kind of intuitively. It doesn't have to be a physical act, right? It can be verbal, derogatory comments, and it doesn't have to be based on sex. It can be based on any one of our protected classes, whether it's age, a disability, religion, race, right? We have so many in California that could be at play. So again, this is on a federal level, but take a look because it can still be helpful to understand those different examples. And then I would encourage you to take that next step and make sure your supervisors are trained on that because they have a legal obligation to report harassment that they knew or should have known about. All right, another developing area that I want to talk about is artificial intelligence and AI. It seems like we can't really get away from it, right? So there's this new case, Mobley versus Workday, and this was, again, at the EEOC level. So the EEOC argued that this AI company that provided resume screening services may be directly liable for discrimination. So what was alleged is this resume screening tool was screening out, I believe it was people over 40, so that's an age protected class, and then people with disabilities. And so it was disproportionately impacting those protected groups. And remember, even if that happens inadvertently, it's not intentional, they could still bring a discrimination claim based on that if there's no legitimate justification for it. And that could also put the employer on the hook in using this AI company. So we want to be careful and proceed with caution as we use AI. Be thoughtful about it, especially if you are using it for those recruiting functions. Just give it a second thought and see, is there a way that we can make sure that this is not happening? The Civil Rights Department in California also has some proposed regulations that they're working on right now to increase AI enforcement and limit employer uses. So this is a topic I think we're going to continue to hear more and more about, and we're going to see more regulation on it because right now it's kind of just uncharted territory. So proceed with caution. We would recommend that your company leaders are monitoring AI developments and consider forming an AI team to track that. And there's a wide kind of spectrum on where employers fall. Some people say we want to take advantage of AI and use it as much as we can. We have some people that say, I don't like robots. I want nothing to do with it. It freaks me out. And then a lot of employers fall somewhere in the middle. But either way, consider a policy and training for your staff. Decide what are permitted uses, what are prohibited uses at our company, and make that really clear, because otherwise employees are going to make their own assumptions. So if you are a CEA member, we do have a sample AI policy that you can use and incorporate into your handbook on our HR forms page. All right, and then the last bill that I want to talk about is this proposed bill. So I want to be very clear, this has not passed. California's proposed bill, AB 2751, would basically create this right to disconnect from work. So how it would work is that if the employer would have to define their non-working hours. So let's say they say our working hours are Monday through Friday, 8 to 5. Anything outside of that would be our non-working hours in a written agreement. And then they would not be able to contact employees during those non-working hours, and unless it was an emergency or a scheduling issue, like we're going to schedule you for the next day. And it would give employees the right to ignore any communications from the employer during those non-working hours and file complaints with the labor commissioner if they reached out a number of times to them during those non-working hours when they weren't supposed to. When I first saw this bill, I admittedly had a little moment of panic because it was so broad and so vague with so many open questions about, well, how is this exactly going to play out? And what about exempt employees where they're not really paid by the hour work? So how's this all going to work? I don't think this bill in its current form is going to pass this year. It didn't make it out of committee. So it's not to say that it won't pass in another form, but I think the legislature did realize that, we need to clean this up a little bit and probably tighten it up and clarify what we mean here. So I think this is one to watch out for, but it might not be immediate. We might not see it this year. But it's California kind of taking a page out of some European countries' books that have already done something similar. So a great way to stay tuned with kind of these updates as they come is to follow CEA's blog. Anybody can do that, whether you're a member or not. You can subscribe at employers.org. We make it our job to track these kind of updates and let you know as soon as we can. So we do encourage you to follow our blog at employers.org. Yeah, so as Nancy clarified in the chat, it has not passed. It is not the law, so it is proposed. And again, like I said, I don't believe it's likely to pass in this form.
I was in Sacramento in May doing advocacy. We talked to quite a few legislators about this and gave them examples of how it could affect people. And at the time, they were thinking it was going to also apply to exempt employees, but it's not, of course. But it's kind of crazy. Like, so literally, some of the things that it was stopping you to do are things that you would have to do to make those other things happen. Does that make sense? Like, like it's like a domino effect. So if I was going to call FEMA to tell her that the building's burning down or something, that's an emergency. But there was other things written in there that did not qualify that as an emergency. And so that's probably why it's on hold. So it's definitely bad language. And we'll probably come back in another alliteration either next year or see what happens.
Right. And I'm hoping if it does that it is limited to non-exempt, because I just think that's going to really complicate things for exempt employees. Or better yet, maybe not at all. We'll see.
we didn't talk to any legislator that was really like, yay, we love this,
That's really good insight. So yeah, and it didn't make it out of committee. So I think it's highly unlikely in its current form. And sometimes bills do just kind of go away after an idea has been introduced. So
well, if it's an assembly bill and it hasn't made it out of an assembly committee, it's not going to happen this year because everything's now in the other house.
Yeah, they would have to do something weird, like through the budget process, gut and amend another bill, and I just think that's unlikely.
They're done gutting and amending. They're out of time, I think. They'd have to bring it back in August or after recess.
Right. Yes. So yeah, I'm not thinking likely. All right, so that's some good news. So now to just kind of wrap up on what we've talked about today, you're going to want to ensure you are paying your employees properly, pay attention to those local minimum wage requirements, and we want to make sure we are capturing all those hours worked. We really don't want to be allowing for that pre and post shift work that's off the clock. Make sure you're in compliance with the workplace violence prevention plan requirements by that July 1 deadline. Do your best efforts to get in compliance with that. That's really the highest priority item that we talked about today, in my opinion. And then consider policy and training updates regarding pregnant worker accommodations, harassment, AI as needed. Take a look at your policies and just see, do we need to tune anything up? And then follow our blog at employers.org. So I want to just note really quick, if you are interested in CEA membership, we do have different membership options. So our lowest would be at $109 a month, and it would give you access to call into us, get that workplace violence toolkit and all of our other forms, free harassment prevention training. And then if you need a little more assistance where you might say, well, we really do need our employee handbook, or we want some training for our supervisors, those ultimate premier packages might make more sense for you. And then we also have an HR Assist program. If you need more of that day-to-day HR help, we can send a dedicated HR advisor that has the benefit of working with CEA's team to help you out. So for example, if you're really trying to get your HR department off the ground, or somebody does go out on a leave of absence and you need to temporarily fill that, we do have a number of options available. So we have our flyer there where you can see pricing and different levels. So we encourage you to take a look at that, and you can give us a call if you have questions about that. So again, I want to give a big thanks. Yes, Nancy?
Someone wrote in the chat, what if in general we have only 9 employees in our office at any given time, but there are meetings with other people at corporate? Would we need to have the workplace violence policy? Yes, you do.
Yeah, my guess would be yeah.
I mean, it doesn't go by
It's
how
at
many
any
employees
given
you have.
time. Yeah, it's at
Right.
any given time. Yeah. But I know. There's a lot of questions around that exception in particular. So again, thank you, Nancy, and thank you to the Greater San Fernando Valley Chamber of Commerce for sponsoring this event today. We really appreciate it. I do have a QR code